Welcome to Chapter 2 in the Constitutional Foundation's Top 12 Highlights from Chapter 2. I'm Mr. Rodman. Thanks for joining me. Let's kick it off by talking about the U.S. Constitution. Article 1 gives you all of the details and duties and powers of the legislative branch, how it's composed, what powers they do have. Article 2 talks about the executive branch or the president. Article 3, we see the judicial branch, also including the Supreme Court, federal courts, and so forth. Article 4, we look at federalism, the sharing of power between the national or federal government and state governments. How do states maintain relations? All of this outlined in Article 4. Article 5, we find out how to amend the Constitution. We'll look at that in greater detail coming up. Article 6, we'll look at the Supremacy Clause, the idea of when national and government conflict, who wins? The case of McCulloch v. Maryland would tell us that. Can the state of Maryland tax a national bank? Answer, no, they can't. Supremacy Clause in Article 6 basically says when national and state government conflict, who wins? The national government, every time. And in Article 7, we find out how to ratify the Constitution. 9 of 13 states were needed in order to ratify this U.S. Constitution to make it the law of the land, and that was outlined in Article 7. We would then see the first 10 amendments, known as the Bill of Rights, be added, and you can see those here. And then we go on to talk about the additional 17 amendments that were added in addition to that, since those first 10 amendments, the Bill of Rights, were amended as part of the Constitution. Federalism, the sharing of power between the national and state governments. Remember, the national government on the left hand, state government on the right hand, they're shaking hands, they're sharing power. Why is this so important? Because if you remember back to the ideas that Madison was trying to create in drafting the Constitution, the whole idea was to limit the power of any factions, Federalist number 10, the power of factions from gaining power over all parts of government. So if you break up government into branches and levels of government, you have a pluralistic theory of that influence, and it's really hard for any faction or interest group to gain control of all levels and all branches all at the same time. This limits the power of factions within government, and that was the idea behind federalism. No one faction could gain control of all powers, levels, and branches of government at the same time. Now, think Montesquieu when you think separation of powers. This was his idea, and this was also outlined in Federalist 51 with Madison when he talked about this idea of power being separated into different branches. The legislative branch would make the laws in Article 1 that's outlined of the Constitution. The executive branch in Article 2 is going to enforce the laws, and then the judicial branch is going to interpret those laws. And the idea here is that by placing separate powers and roles and responsibilities essentially within each branch, it was going to help separate the type of power and the roles they would be responsible for. Now, this obviously wasn't enough. We needed the idea of checks and balances to make sure any branch didn't become more powerful or tried to usurp power from the other branch. And here we see the legislative branch is checking the executive branch by approving presidential nominations. They have the power of the purse. They're controlling the budget. They can override a veto, and they can impeach the president and remove them from office. Now, their check on the judicial branch is to confirm the nominees to the court and impeach judges or remove them if they find them guilty and can convict them in the Senate, in the trial that's held in the Senate. Now, the executive branch can check the legislative branch by vetoing legislation. They can also check the judicial branch by nominating judges. Now, the judicial branch finally can check the legislative branch by declaring laws unconstitutional, and they can check the executive branch by declaring presidential acts and presidential orders unconstitutional, which then means they are null and void, and they do not have the full effect of law any longer. So these are the checks and balances. I highly advise you go back and look at these in more detail, but hopefully this gives you an overview of those checks and balances on each of the branches and on each other. So we have divided government when we have parties that share power, such as one political party controlling the legislative branch and one political party controlling the executive branch. This was by design. The founders did not want government to be able to very quickly and half-heartedly to pass laws and get them through Congress and signed by the president easily. They wanted this to be a process that was slow and deliberative. yet meaningful to the people of the United States. And so that's why we see divided government and this sharing of power in many respects is gridlock in terms of getting things done. But the idea was that it would be a slow and deliberative process in doing so. Even in a unified government with one-party government, when you have Democrats or Republicans controlling both the legislative and executive branches, you see differences even among the same party in terms of their ideology and their ideas and their beliefs in terms of what they want to accomplish and what their agenda is. So even then we see to some extent they're not to the extent we would see divided government among the parties sharing power, but the idea there is that there is a slow and deliberative nature to all of this that is outlined in the articles and the separation of powers. Judicial review, this idea of determining the constitutionality of a law or order, was not explicitly given to the courts through the Constitution. It was one of those powers that through the court case of Marbury versus Madison, which we'll talk about in a second, the courts basically assumed that role and have had a strong role ever since. Federalists like this option. They favored judicial review and wanted the courts to have a role. And as we can see, they've done that in more than 175 different congressional acts in determining them unconstitutional. This came about from the case of Marbury versus Madison. Madison being the Secretary of State for Thomas Jefferson, the president at the time. Jefferson was conflicted on this. He didn't necessarily want Marbury to gain his appointment under Madison and the midnight appointments, but he also didn't want the Supreme Court prying into what he deemed to be his business in exercising judicial review and declaring laws or orders unconstitutional. He did win. Madison did win. The court did rule in favor of Madison and ultimately Jefferson that Marbury didn't get his post, that the new president didn't have to honor the midnight appointments of the old court. However, it did give judicial review power to the Supreme Court, and today we widely accept that as ruling on the constitutionality of laws, but back then it was a new concept. Also, keep in mind that litigation or filing a lawsuit by an outside group or an outside person in a case where there is a law that's been passed is one of a very common way for people to bring judicial review to a law in terms of the courts taking a look at it and determining its constitutionality. And we saw this with the line item veto that President Clinton signed, and many examples of different laws that have been passed over time and some that have been ruled unconstitutional. In terms of methods of changing the meaning of the Constitution, elaboration is one of those filling in the blanks type of places where the Constitution may be vague or maybe doesn't quite outline the role that the branches play in this regard. And the role in Article 1 of Section 8, the role of Congress in basically maintaining it and creating the structure of the courts is what we see in the Judiciary Act of 1789. This basically called for the way that the courts are set up and still used today in that role, especially in the lower federal courts, the appeals courts below the Supreme Court. Impeachment is another method of changing the meaning of the Constitution. What is the role between the executive and legislative branches, with the House being able to impeach presidents and judges and other and cabinet officials? What is high crimes and misdemeanors? It is so vague, and yet we see all the time we've had 2 presidents impeached, a senator, a secretary of war, and many judges. But again, this changes the meaning of the Constitution in terms of the role that Congress plays in determining impeachment articles, and then ultimately in the Senate in holding the trial for these impeachment articles. So again, this changes over time the role of impeachment in that process. Flipping over to the executive branch, then we look at the executive orders and presidential acts. Many times we see the president using power in times of crisis. Executive orders, a great example of this because they carry the full force of law. A presidential act, very similar to that, pretty much the same as an executive order in carrying the full force of law. They can be challenged in court. Many times they are. But the idea is if Congress is in agreement with the president on it, they're probably not going to do so. And in one of the most recent recent cases, President Obama basically saying Congress isn't doing their job, so let's pass an order looking at immigration. And now the courts are stepping in, saying in appeals courts or in some of the federal courts, saying parts of it are unconstitutional. So to be continued to see how the Supreme Court will, if they'll take that up and what they'll say about it. But it does show you the check and balance process at work there. Number 10, we have judicial review, and this, now that we have this judicial review, we look at judicial interpretation. How do the courts interpret the laws in many cases? We see this in Brown versus Board of Education, the 1954 desegregation case, in which Thurgood Marshall, the later Associate Justice to the Supreme Court and the first African American on the court, basically arguing for Brown that the schools need to be desegregated. And a unanimous decision by the Supreme Court basically overrules their earlier ruling in Plessy versus Ferguson, 1896, that basically said separate but equal was the law. So this judicial interpretation essentially becomes law and changes the role of law in interpreting the Constitution. Griswold v. Connecticut claims a right to privacy using the amendments 1, 3, 4, and 9. This right to privacy is then used as a precedent in Roe v. Wade in determining the abortion law that was passed, that was ruled and interpreted to be constitutional in 1973. So the idea here is there's a lot of judicial interpretation, and we're going to look at many of those when we get to the Civil Rights and Civil Liberties unit. But the idea here is that the courts are ruling and creating law through their judicial interpretation, and that's an important role that we see them play today. They do have an originalist versus adaptive stance, and if you look at many of the justices, they either fall into one of these two categories. Originalist is kind of this strict construction method in which basically the Constitution is fixed. The original text is what we're looking at. What was the original intent of the founders when they wrote this? And that's really a strict constructionist or an originalist point of view. The adaptive or loose construction is more interpretation, leaving it to interpretation in terms of, well, what would the Constitution, what would the founders have said about the Constitution in relation to the internet, or regulating the internet, or passing laws against it, or for it. And this loose construction is kind of interpreting in today's day and age what the founders may have done. So looking at the Constitution in a more flexible or responsive method, and this is where we get the loose construction versus strict construction. Along those lines, we tend to see strict constructionists tend to be more conservative, loose constructionists tend to be more liberal, not necessarily falling along those lines by party, but definitely by ideology. We tend to see more originalists more along the conservative ideological part of the spectrum, and the loose construction or adaptive tend to be more on the liberal end of that ideological spectrum. In terms of amending the Constitution, we went over this one in class, but I think that this bears repeating. So we look at the first column, or phase 1. Congress can propose an amendment. 2/3 of a vote is needed in each of those houses, and then they can send it to state legislatures where 3/4 of the states need to ratify it. Then it becomes law, okay? And we have done that for every amendment except the 21st, the idea of repealing prohibition. Now, we also have an alternative method, actually several. Congress can also send it to state conventions. We have not used that but once in terms of state conventions repealing the 21st Amendment prohibition. We can also, in phase 1, call for a national convention in which 2/3 of the states are basically requesting the proposition of an amendment, and then sending that to state legislatures or state conventions. But again, both of those have never been used. So when we've seen the 27 amendments, 26 of them have been from Congress, basically proposing an amendment by a 2/3 vote in each house and then sending it over to the state legislatures over here in phase 2. So again, 2/3 in the first column, 3/4 in the second column, and basically this is the way that most of the 26 of the 27 amendments to the Constitution have been ratified. Now, keep in mind that a state cannot unratify an amendment. They once they've ratified the amendment, and a great example of this would be prohibition. They can't go back and say, "Okay, we changed our mind," and that's why they had to go forward with another amendment, basically taking back their earlier amendment. There isn't a time limit unless Congress specifies one, and typically we would see that as a 7-year time frame. And I know we've talked about this, but the 27th Amendment is probably the best example in terms of Congress giving themselves a pay raise. It took 203 years to ratify that amendment to the Constitution. Was originally proposed as one of the 12 amendments that were originally proposed in the Bill of Rights, but obviously wasn't ratified, so only the first 10 were. But that is a great example of amending the Constitution, how sometimes it takes a little longer to get things done. And then lastly, when we look at this, one of the things that we see in the Constitution, and especially in the amendments, is the expansion of our electorate, who gets to vote. This is definitely a move toward more direct democracy. Now, we're not always going to see that these groups come out to vote in numbers, and we'll talk about that in Unit 2 in terms of voter apathy and why people stay home to wash the cat and that sort of thing. But we have seen through these amendments, and if you look here, the 15th Amendment, African American men have the right to vote. The 17th Amendment, we give direct election of U.S. senators to the people of the states, so then they're basically electing directly their U.S. senators like they do their House members. The 19th Amendment gives women the right to vote. The 23rd gives D.C. citizens the right to vote in a presidential election. All of these are moves towards a more direct democracy and expanding the electorate to do so. And so while we may feel that more interest groups are more involved and we see various levels of participation in terms of voters and voter participation, the idea is that we have done a lot to move towards that more expanded electorate as a result. I hope you've found this to be helpful in these top 12 highlights, and I highly encourage you to go back and look at Chapter 1, the Chapter 1 highlights and the PDF of that, and good luck on the test.